Friends, good morning. It's nice to see all of you. The COVID-19 pandemic caused us to locked in at home, but we are able to do the better interactions and much closer to each other due to the technology available. And at the same time, we are trying to enlarge and discussion our knowledge in this close era of operations, our day-to-day activities. And today my team has selected the topic for discussion is operation and mismanagement, the basic consciences of the operation and mismanagement. Basically, since this term are very important for the purpose of this we would rather say it is the most prominent corporate dispute. This is we sometimes say it is the family dispute before NCLT, since mostly it is being fought between the very close relatives, friends, and family members. And incidentally, the term operation and mismanagement is nowhere defined under the statute, neither under the earlier English law nor under the 1956 Act, and further in 2013 is left everything open. So basically, it is being dealt through the judicial pronouncements of almost centuries we are having, and which is being followed and upgraded with the time and passages. Certainly, the 2013 Act has made the much more transparency and clarity as far as these litigations are concerned, and the procedures and with the better and more professionally empowered tribunal. Then thank you very much, and it is going to have I just would like to have it is a most interactive session. We will just after the sharing my thoughts and the sharing the judicial pronouncement, we would like to have your views and to take it forward. I think next 40-50 minutes I will be taking to submit my viewpoints in the and what were the research done by my team on the subject, and thereafter we can have the views of the participants, friends, and go ahead. This is the topic is especially restricted to the term operation and mismanagement. Since the subject is too wide, the team is purposely selected to just examine, since these two terms are very important and vital for admission or rejection of the petitions. Coming to the point, basically section 241 to 244 of the Companies Act deals with this 2013 Act, deals with the provisions of this act, and the law related to the prevention of operation and mismanagement in the chapter 16 of the act. And basically it is the minority interest. Generally the law is well settled unless there is something very serious prejudice is caused to the minority, majority is allowed to operate. That is the concept of this minority protection law, and that's why it is a very pinpointed has to be that. And there are a lot in NCLT as well as the judiciary is empowered very wide powers under the statute to enforce the strict action of the company and management as well as the majority members. And the provisions are almost similar to the earlier we were having the under section 397 and 398 of the Companies Act. Coming to the, yes, next slide. Next. Yes. As I just pointed out, basically these four sections are dealing with the provisions of the statute. Basically, the important section is 241, in which the application is being moved to NCLT. Subsection 1 dealing with the minor by the members having the requisite numbers and majority, and the subsection 2 deals by the central government.
Yes, sorry to interrupt. I would request all the attendees to kindly click on the presentation at the right corner so that the presentation is visible all over the screen. And also, I would request all the participants to keep themselves in the video off mode. Thank you.
Yes. Yes, friends. I was discussing there are four sections of the Act as dealing with this provision. Subsection, especially section 241 deals with the application before NCLT. Subsection 1 by the member having the requisite numbers, and subsection 2 dealing with the powers of the central government in the situation, something prejudicial to the interest of the company and its own power and power. And 242 is the most important, in which the powers of NCLT to pass the directions and orders under the Act. Subsection 1 is dealing with the general powers, and subsection 2 is having the wide some list of the specific directions, including directions to buy back of the shares at the consideration decided by the NCLT. And then coming to section 243, is the certain, even the power is having to termination and modification of the agreements of the company. So that is also power with the NCLT. 243 deals with the consequences of such impact. And again, I was just pointed to 44 deals with the eligibility criteria of the applicants. Again, the NCLT is having inherent power to consider even the application with the person having a very nominal, say, even 100 shares of the company. Yes. Next. Basically, these two terms, operation and mismanagement, are having the very wide importance. This is the entire Act is based on these two terms. Basically, incidentally, the both terms have not been defined as suit per se, and if it has not been defined, it is left for the court to decide on the basis of facts of each case as to whether there is any operation and mismanagement that requires an action taken under this section. Since it is everything is left on the court. Yes. Next. Just I would like to take you the legislative history behind this provision. In the way back in 1943, under the English Act, a Cohen committee was constituted, and on the basis of recommendations of the Cohen committee, first time the provisions of operation was introduced in the statute book in 1948, under section 210 of the English Act prior to 1956 Act. Again in 1952, the importance of mismanagement was being realized, and on the basis of Baba committee, this amendment was taken place in 1963 in our 1956 Act, by making suitable amendment under section 396 to 404 of the previous Act. This was introduced at that point of time. Yes. Next. Go to next. Yes. This remedy confirmed in the chapter 16 of the Act, which is similar to the British law as well as 1956 as to some extent, is an unfair practice, a prejudice to the remedy prevailing. It is a correspondence to the unfair prejudice remedy prevailing in the UK itself. And the unfair prejudice remedy is based on the premise that the shareholders' petition, if court is satisfied that a minority of the shareholder is being oppressed and that a winding up order would not do justice to the minority. There are two things. One is there is the prejudice to minority, and which is at the same time is creating a situation. The committee's case is going to be towards fit case for the winding up, but at the same time, this winding up action may not be do justice with minority. That's why this provisions were inserted in the issue. Next. Next. Since defining both terms are based on the terminology of the jurisprudence fixed by the courts, That's why it is now important to deal with the various judicial pronouncement on the basis of which it is decided. Just way back in 1987, I would like to just take you the judgment of Madras High Court in the Rajeshwari Ramakrishnan, V.M. Rao versus Rajeshwari Ramakrishnan, in which the court has given a very finer points under which situation it can be taken up. Basically, number one point they have pointed out, the complaint must be affect a person in his capacity and character as a member. It is basically these provisions for the member of the company, not to otherwise, not in the capacity of director, creditor, or in other capacity. It is this particular provision is available for the members only. This is the basic one part. And again, the harsh and unfair treatment in any other capacity as a director, creditor is strictly outside purview. In the certain cases, has been dealt in the past, but strictly it is outside purview of this section. And second part is that there must be the continuous constituting operation up to the date of the petition. Not a single action would not be appropriate. It has to be the complete action would be appropriate. It has to be continuous action. And third one is the event have to be considered not in isolation, but a part of the continuous story. We will be taking even a continuous story. Something, if it is in the past has been done on that basis, you cannot be forced it. We will be taking it. It is a continuous story. And again, there must be shown as a preliminary fact to the application that there is a just and equitable ground for the winding up. Again, all these grievances and prejudice is ultimately creating a situation for the winding up of the company. That is the basic thought process of the legislation. The conduct complained of can be said to be oppressive only if it could be said to it's the burdensome, harsh, and wrongful oppression. Involves at least an element of lack of probity, fair dealings to its members, as it's their proprietary shareholder rights as shareholder. It is just as their proprietary right is something is the missing, and there is an element of lack of probity and fair dealing. These are the certain very fine border points emphasis in 1987 by Madras High Court, which is still very relevant while dealing with such situation. Just taking to you next slide. Another very important landmark judgment of Kerala High Court, which is being dealt in from over the years since 1994 in the number of most of judicial pronouncement by the even apex court. Even in the post NCLT, we are coming across with the relevance of this judgment. Just one important para I would like to just reproduce in front of you. I would like to read for the benefit of our friends. The expression operation and mismanagement, which are the core concepts in this section, are left by the legislature without defining them. When once it is left without definition, the task of court is difficult and the more responsible. Certainly, if something is left on the court, is going to be the difficult and responsible. When there is discretion, there is a onerous responsibility on certainly the person. And naturally, the court will always incline to wade through the precedents to find out and to assign the correct meaning of these two words, operation and mismanagement. And in the context in which they are used, certainly the courts have to decide on the facts of each case. It is basically the facts are more important. All the litigations of operation and mismanagement as against the law. It is depend upon the case-to-case basis, and on the identical issue, there can be the different verdict and different conclusion. This is the very important situation. The facts are very important, and whether there is a real cause of action under section 397 or 398 of the Act or not. Next. Further, another important judgment we would like to bring. There is the Honorable Supreme Court in 1982. They made the observation, just taking the very 4 lines of that judgment, which is just in front of you. It is a well-settled canon of the construction that construing the provisions of such enactments, the court should adopt that the construction which advances the fulfillments and furtherance of the object, rather the one which would defeat the same and render the protection illusory. This is a very important observation. This is the equally applicable in other branches of the law also, but the law has to be which should advance the fulfill and furtherance of the object which supports, rather not defeat the object of the law. This is a very important observation of Honorable Supreme Court, which is the relevant while we are going to deal with the cases of operation. Next, since everything is left on the judicial decisions and precedents, and now we will further taking it to the in that way. Yes, please. Just to start with, I will be taking you the old judgment of the English case in the Scottish in Company Elder and Elder Watsons. The 4 lines again very important, which I would like to just read. The essence of a matter in it seems to be the conduct complained of should be at the lowest involvement of visible departure from the standard of fair dealing. It is very important. Something should not be, it is even the lowest involvement of visible departure from the standard of fair dealing and a violation of the conditions of fair play on which every shareholder who entrusts his money to a company is entitled to rely. This is very important or observation, even it is very relevant today and being followed by the court while deciding the matters of operation and management. Another very important judgment of again English court in 1983. The relevant para is again very important to just touch upon. The test of unfairness must, I think, be an objective, not a subjective. It has to be objective, not a subjective. And in other words, it is not necessary for the petitioner so that a person who have had de facto control over the company have acted as they did in the conscious knowledge that this was unfair to the petitioner, that they were acting in bad faith. The test, I think, is whether a reasonable bystander observing the consequences of their conduct would regard it as having unfairly prejudiced to the petitioner's interest. Whether it is done intentionally or unintentionally, that is becoming irrelevant. This is the important observations. Yes, next. Now taking you to the another landmark judgment of Honorable Supreme Court in the matter of Kalinga tubes in 1965 itself, in which these 6 lines are again very important. I would like to just read for the benefit. The conduct must be burdensome, harsh and wrongful. These 3 terms are very important. Conduct must be burdensome, harsh and wrongful, and further a mere lack of confidence between the majority and minority would not enough. This is another observation very important. It is a mere lack of confidence between majority and minority cannot give the right to for operation and mismanagement. It is basically the conduct must be burdensome, harsh and wrongful. And again the minority confidence between them can be the situation unless the in case of the lack of confidence springs from the operation of minority and majority. If it is that confidence is immersed on account of operative act, then it can be an issue in the management of the company's affairs. Such operation must involve at least an element of lack of probity and fair dealing. These 2 term word is again taken from that English judgment, lack of probity and fair dealing to a member in the matter of his proprietary rights as shareholder. This is very important observation of the Supreme Court. Coming to you, another important judgment of again English court. The operation occurs when the shareholder having a dominant power in a company, majority shareholders, either exercises that power to procure that something is done or not done in the conduct of company's affairs, are procured by an express or implicit threat of on exercise of that power that something is not done in the conduct of company's affairs. Acts can be construed to constitute operation even when acts are committed without any aim of pecuniary advantages. It is not necessary to show that it was done, this operation was done for some benefit. Even without benefit, if something is the oppressive act is done, that is the case is caught in the purview of that. Yes, next. Interestingly, coming to the another limb of mismanagement in the chapter 16 of 2013 Act, although header is talking about the mismanagement, but the provision itself strictly doesn't talk about the deal with the mismanagement's word per se. Instead requires that prejudice to the company's interest or to public interest as a result of the conduct of company's affairs. These three words are basically important. One is the something prejudice is caused to company interest or public interest. These two interests prejudiced and as a result of conduct of company's affairs. This is the, incidentally, again, these terms where we have not come across with the defining anywhere, but for the sake of our better understanding, I was able to go through the commentary of leading corporate practicing company secretary and past president of ICSI, Mr. Chandratre, in his commentary, in which he is nicely deal with this subject in his commentary. Just I would like to touch upon before taking it further forward. While dealing with the subject of prejudicial to public interest, I will read the few lines of this portion. The element of public interest into the management of companies after 1963. The management corporation has become the accepted instrument of social policy. Being the corporate, you are having a lot of social obligations. It is not, and being the part of the society, corporate society now today. And because it affects a large part of economic life of the community also, and it has become an instrument for improvement of economic standard of the people by way of paying taxes to the government or by way of serving to employment and number of factors which the corporate is expected and doing it. And for economic growth of the nation, society depends for some of its needs on the corporate enterprises. Basically, this is the basic version. It has therefore an interest in the stability and efficiency as an economic institution is relevant. So this is the basic, these four observations for in which the public interest, whether having the proper responsibility as a paying exchequer, whether making the compliances of the laws, whether making obligations towards the states, all stakeholders. This particular four line we are taking us to the too wide definition of the public interest, in which the very wide gambit, and it can be attracted in this case. Yes, next. Again, these act of has to be related with the conduct of company affairs. This is second limb. Limb is the under response. While dealing with this subject, again, in this commentary, Mr. Chandratre has observed the term conduct of the company affairs is not synonyms with the conduct of company's business nor the conduct of the management. Basically, conduct of company affairs is very too wide in terms, and it includes the all aspects and gambit of the company. It cannot be restricted to merely with the business or the management of the company. And he's put upon the various illustrations while dealing with this. Next. We are now just going to touch upon the certain judicial pronouncement. In the certain cases, the judiciary held it is the case of oppressive, and in certain cases, it is not the oppressive. So we are going to touch upon these judgments. Basically, again, the very important judgment of Honorable Supreme Court in 2005, and the very important observation Supreme Court has made, that operation complaint must have relate to the manner in which the affairs of the company are being conducted. Entire manner of the, not a particular act, and conduct complaint must be such as to be sufficient enough to oppress the minority. Not a single cause of action cannot create. It is a very, has to be the entire affairs. You have to just point out the observation of Supreme Court in the case of Gaikwad and Gaikwad. And again, this English case in the HR Harmer, word oppressive mean the burdensome, harsh and wrongful, as we earlier also discussed. Further, it was held that the section does not purport to apply to every case in which the fact would justify the making of a binding up order when the just and equitable rule, but only in those cases that character which have in them the requisite element of oppression. In all cases which is the fit case of winding up, you cannot put to the oppression. Rather, if it is the case of oppression and the having the some element of the winding up, then certainly it can be case into the form that it was also held that as a result of the applications under section 210, it was the section of English Act, that in different cases must depend on the particular facts of each case, the circumstances on which the oppression may arise being so infinitely various that it is impossible to define them with precision. So basically, the law is more on the facts, and every fact to fact, even the court has gone with the different conclusions. There cannot be one identical stick to on the issue based. It has to depend upon the facts to facts. Next. Again, the relevant observation of the Honorable Kerala High Court in Palghat exports, which after dealing with the certain English judgments, they have observed that fact of the case should disclose and unfold to invite then an interference that there had been at least an unfair abuse of power and an impairment of confidence in the probity with which the company's affairs are being conducted, as distinguished from mere resentment on the part of minority at being outweighted on some issue of domestic policy. So again, the same thing they have reiterated, that the mere resentment is not relevant. It has to be the unfair abuse of power and impairment of confidence. That is the very important in probity, rather. That is the important observation. Again, coming to the relevant portion of one very important judgment of Honorable Gujarat High Court in the case of Seth Mohanlal Ganpatram. In 1964, Gujarat High Court made the observation, it is being designed to suppress an acknowledged mischief. This should receive the liberal interpretation, and the court should give such construction as will advance the remedy. This is the very important observation. Just for this purpose, I would like to take you the relevant paragraph of Gujarat High Court in this case. Which is in this case, Gujarat High Court, they have categorically told that they have to go to come to some conclusion to reduce that. In the last line, now is certainly counsel certainly right in his supersession of 397, 398 being designed to suppress an acknowledged mischief. And it is if something is acknowledged mischief, it is suppressed. Then it is going to be the liberal interpretation, as just I read you. And the court should give the construction, will advance the remedy. It is mainly some remedy should come out of that. This is the observation of Gujarat High Court in this case. Next, coming to the very important landmark judgment of Kalinga Tubes, in which they have followed the earlier judgments of English court and made this observation, which is very important. The question in each case is whether the conduct of affairs of a company by the majority was oppressive to the minority shareholder. That depends upon the facts proved in a particular case. This is one very important. And again, it is not enough to show that there is just an equitable cause for winding up of the company, though that must be shown as preliminary application to Section 97. Yes. And it must further be shown that the conduct of majority shareholder was oppressive to minority as a member, and this requires that the event have to be considered not in isolation but as a part of constitutive history. There must be a continuous act on the part of majority shareholder continuing up to date of petition. Even though now the jurisprudence is improved, certain even during course of petition is also being sometime examined by the court, showing that affairs of the company as being conducted in the manner oppressive to some part of the members. The conduct must be burdensome, harsh, and wrongful. These three terms are very important, and a mere lack of confidence between the majority shareholders and minority in the management of affairs, and such a person must involve at least an element of lack of probity or fair dealing to his property out as shareholders. This is the very crux and a very important. Yeah, next. Now I am just taking you across the number of judgments which may be relevant, in which the minorities' applications were admitted by the court, and it was again upheld by the higher forum also. Before taking you to the number of judgments in which the similar issues, it is even the not admitted and thrown by the judiciary. First, I would be taking you to in the various instances. Number one, obviously, in case of Scottish matter, when the power exercised by the controlling shareholder is directed or necessarily towards the destroying the company's business operations. If it is just that majority power is being used to destroy the company's operation, then certainly it can be a case of the operation of and entering the petition under this section. And then again, the Honorable Punjab High Court in the matter of Mohanlal Chandumal in 1962, even the denying the voting right to the shareholder expressly or by necessary implication is going to be a case for internment application. Again, another judgment of Calcutta High Court, in which even the directors refused to distribute the compensation money obtained on the legislation of the company, that was taken as a ground to entertain this application. The company undertaking the business other than those mentioned in the object clause without calling a general meeting or passing a resolution, that was also taken as one of the issue to entertain this application of operation. Yes, next. Again, the Delhi High Court in the matter of B.R. Kundra versus Motion Pictures Association in 1978, even exercising the powers by majority to expel the members. This is the power is being used widely in number of cases. Even they have held if it is that power, but there are maybe contradictory views that having lot of issues are coming in that also. But whether what was the intention and how it is expelled and which situations, this is going to be relevant. That is going to be another important issue. Again, the Calcutta High Court in the case of this Suranjan Datta versus Bholanath Paper House in 1983, the deadlock created in carrying out the affairs of the company due to lack of faith between two factions of the company and family. If there are two branches and there is complete deadlock in the affairs and you don't have other option, then it's ideal to entertain the application. The directors and many directors consistently not functioning in their office. This is the case. And again, in case of Chandrakishan Gupta, the Delhi High Court made the observation that the directors are not taking interest in the affairs of the company and always quarreling so as to cause loss of the company. This was ultimately creating the loss for the company. That's why they entertain the application and pass the appropriate order to resolve that issue. Yes, next. Again, very important judgment of Honorable Supreme Court of 2008 in the matter of MSDC Radharaman. Very important observation. In this case, even without the finding of operation, the certain orders were passed. and that was the order of CLB was upheld by the Honorable Supreme Court. And very important observation, I think, has to be just to bring our notice. The Company Law Board held that there was no operation on the part of the appellant. While passing the order, the CLB has purposely, categorically noted there is no operation on the part of appellant. However, opined, even without opined that there existed deadlock in the affairs of the company and directed appellant to buy some shares from the respondent number 1 to remove deadlock. This is very unique judgment in which even without the agreeing there is any case of operation, the court has gone ahead in directing for buyback of the shares. This is the unique case. And on the appeal to High Court, the Honorable High Court held that the Company Law Board was right in arriving at the conclusion that there existed deadlock situation, relying on deadlock situation, and hence the present appeal by the allied. And then the Honorable Supreme Court upheld the CLB's order and made this observation: whether the Company Law Board ousted its jurisdiction by directing the appellant to purchase shares held by the first respondent when an application for winding up on the ground of operation was filed by first respondent, and when the board itself had agreed that there existed no operation by the appellant. Even in spite of no operation where the CLB was right in passing that direction, this was the issue before Honorable Supreme Court. And the Honorable Supreme Court held that in case where the case of operation had been made a ground for the purpose of invoking the jurisdiction of the board in the terms of 397, 398 of the Act, a finding of the fact to that effect would be necessary to be arrived out. And but the jurisdiction of Company Law Board to pass any order or further order in the interest of the company, if it is of the opinion that the same would protect the interest of the company, it would not be powerless. This is a very important observation. And jurisdiction of the Company Law Board in that regard must be held to be existing, having regard to the amended provisions, and therefore the CLB has rightly exercised this jurisdiction. Yes, next. Again, the Honorable High Court, Calcutta High Court, in the matter of the combust technique, made the observation that in a company where there is only 2 shareholders who are directors and 1 director who has got the majority shares refuses to cooperate with the affairs of the company and exhibiting mutual lack of confidence not to be settled otherwise than by taking it to the court by mutual domestic policy. This is in such situation, again, in situation of deadlock, the Calcutta High Court has decided it is the appropriate case to entertain the application. And again, in case of Kumar Exporters Private Limited in 1986, the Allahabad High Court made the observation that if the directors refuses to register the shares in the name of complaining petitioners with an object to retain the control over the affairs of the company, that can be treated as the case of operation to its members, minority shareholders. Next. Now, I would be taking you to some of the important judgment which is in which the application is dismissed by the authority and upheld also at the higher forum, and on the basis of facts of each case, and which may be relevant to examine, since it is a general rule of law is the majority to prevail unless something is basically specifically found that the serious prejudice is caused to the minority. So on the basis of that, the most of applications are being examined to throw at the threshold only. And that's why the certain important judgments we are just taking to for the sake of our discussion. In the matter of Lalita Rajalakshmi, the Calcutta High Court in 1962 made the observation. The court held that the denial of access to or inspection of or books of accounts of the company to the petitioner may not amount to act of the operation. This is a very serious observation, uh, of the court. This is as a right of shareholders, that is a case of denial, but anyhow the court has found in that case it is not the case of operation. But I think the law will further getting improved after post 13 act, after having the serious compliance obligations under the act, as well as the having the secretarial standard and other compliances. Is the part of the institute. I think this law may be going to have the further improvement in the coming period. Coming to the another judgment of N. Krishna Prasad of Andhra versus Andhra Bank, it was held that an attempt to get a majority by lawful means is not an act of operation within the meaning of 397. This is the common practice. Mostly the majority is doing in the most of the cases. This is but again, this case is required to be tested in the light of the present legal jurisprudence and with the examination of the proper compliances and proper procedures by the concerned company and proper corporate governance issues. Again, in the case of as we earlier discussed, this Kalinga tubes, the observation of Supreme Court that the issuing the shares by majority shareholder to their friends or outsiders would not amount to an act of operation. In the same case, it was held that a mere loss of confidence amongst the different group of shareholders due to non-distribution of new shares to an existing shareholder would not amount to an act of operation. Again, this is very incidentally, we will be taking you to sum up judgment of NCLT and include post NCLT era. Interestingly, but the most of cases are still continuing on the basis of that we are here restricting ourselves to the operation and mismanagement defining, and most of cases are even the post NCLT era is based on these jurisprudences. And we have come across very few of the judgment which is just taken. We will be taking that also. There was some observation of our DK Jain Sahab in the matter. We will be taking it. Yes, next. Next. Again, in the matter of SR Subramaniam versus Drivers and Conductors Bus Private Limited, 1978, the Madras High Court held that failure to forward the estuary report in the case of a private limited company is not an act which can be considered as an act of operation to invite an action. This is the common complaint by the minority. We have not received this, that, and all this. In this case, again, according to me, it has to be tested in view of the present procedures and law. And coming to the judgment of Delhi High Court in South India Viscose, it was held that mere contravention of some of the provisions of the law by the board and actions being unwise and not prudent may not amount to an act of operation. Just pointing out that certain acts are unwise and not prudent, it cannot be the case of operation. Again, in the case of Suresh Kumar Sanghi versus Supreme Motors Limited in 1983, the Honorable Delhi High Court held that the past acts, very important, the past acts which have come to an end would not be taken for the purpose of invoking the court's jurisdiction under the act. Basically, the past act which was right or wrong, which is already concluded, and that cannot be taken unless that is something is continuing in that connection. That cannot be taken as a cause of action for the operation and mismanagement. Again, in case of Chand Kishan Gupta, the Honorable Delhi High Court held that the stray of illegal acts or isolated acts of controlling shareholders cannot be used ground for an action under 3. Certain pointing out certain illegal acts or isolated acts, unless those acts are certainly going to have some implication and continuity and oppressing the conduct. Yes, next. Again, the Honorable Supreme Court judgment of Lidl Industries, which is a very important judgment, again, in the subject. These lines are again important to just recollect. It's clear from these various decisions that a true construction of this section 397, an unwise, inefficient and careless conduct of a director in the performance of his duty cannot give rise to a claim for relief under that section. This is very, by pinpointing certain unwise, inefficient and careless conduct, you cannot take recourses under the, and the person complaining the operation must show that he has been constant to submit to a conduct which lacks in probity and conduct which is unfair to him and which causes prejudice to him in exercise of his legal and property right as shareholder. Again, this is very important observation. Next, in Click Nixon, the Honorable Bombay High Court made the observation, the act is any personal grievance of any member himself is not contemplated. Basically, it is a cause of action under section 397 is the conduct of the affairs of a company in a manner prejudicial to public interest or in a manner oppressing to any member or members of the company. Again, the personal grievance cannot be a reason to take it under section 397, 397, 8 are present, 241 of the Act. Next. Again, the very important observation of the judgment of the Supreme Court in 2008, in case of V.S. Krishnan and others versus Westport High-Tech Hospitals, mere unfair doesn't constitute oppression. It's very certainly, just I will take you the relevant paras of this judgment, which may be the useful for our discussion. In para 10 of the said judgment, while dealing with the judgments of Mineral Industries and other various judgments, the court has made the observation from the above decision, it is clear that operation would be made out. They made the certain finer points where the conduct is harsh, burdensome and wrong, number one, and second, where the conduct is mala fide and is for collateral purpose, where although ultimate objective may be in the interest of the company, the immediate purpose will result into the advantage of some shareholder vis-a-vis others. This is very important observation. In the ultimate objective may be interest of the company, but immediate purpose, if it is affecting the right advantage of some shareholder and disadvantage to others, then it has to be the case. The action is again against the probity and good conduct. And the fourth point is the oppressive act complained of may be fully permissible under the law, but may it be oppressive, and therefore the test to be whether an action is oppressive or not is based on whether it is legally permissible or not, since even if it is legally permissible, if the action is otherwise against the probity, good conduct, or is burdensome, harsh or wrong, or is mala fide for the collateral purpose, it would amount to oppression. Even having something merely the legal may not serve the purpose. If it is going to be once the conduct is found to be oppressive under section 397, 390, the discretionary power given to the court under section 402 of set right, remedy and put an end to oppression is very wide. There is very wide power with board as to what are the facts which would give rise to or constitute oppression is basically a question of fact. This is very important finding of the court in this case. It is a question of fact. Therefore, whether an act is oppressive or not is fundamentally and basically a question of fact. In the same common issues, there can be a different verdict in the case. Basically, depending upon, again, the para 23 of this order is again relevant we just read out. As rightly pointed out that CLB missed. In this case, the CLB order is passed by the court. missed out a most basic principle of 397, namely mere unfairness does not constitute oppression. When the petitioner were given the right to subscribe the right shares along with the others in the same proportion, no prejudice whatsoever could have been caused to them. It is not the case. Basically, mere prejudice and mere unfairness cannot create a situation. This is the observation of the court. Taking to the next observation of the judgment of, again, the Mohanlal Ganpatram, which may be relevant for this discussion. In this, again, the application was dismissed. Mere finding can be inferred that 397, 398 apply to present continuous wrong. It has to be continuous wrong, and remedy is essentially preventive. And there must exist, and the date of the petition, a continuous course of oppressive or prejudicial conduct of affairs of the company. And there is no power in the court to set aside or interfere with the past and concluded transactions between a company and third party. Cannot be. We do not want to emphasize the fact that remedy within the section 397 is not intended to set at naught what has already been done by controlling shareholder in the management of affairs of company. Something past we cannot do. This is the basic observation of the court in this case. Next. Again, in the matter of Thakur Hotel Simla, the Punjab High Court held that the mismanagement or the misconduct of directors during earlier years is no ground for winding up in a company under just an equitable cause and for making an application under 396 if the mismanagement has ceased at the time of application. On the date of application, whether something mismanagement is continuing or not, that is the very important. Again, the object of 397 not to take up the past but to redeem the future. This is the observation of the court. Again, in case of Rajamundry, the Honorable Supreme Court has made the observation where nothing more is established than the directors have misappropriated the funds of the company, and order for winding up would not be just or equitable, because if it is a sound concern, such an order must operate harshly on the rights of shareholders. Misappropriation of fund by directors, only the misappropriation may not be only case to go ahead for this. Since even after the misappropriation, the company may be fundamentally fine to go ahead. That's why it may affect again to shareholders. This was the operation of Honorable Supreme Court in Rajamundry. Yes, next. Again, the judgment of Kalinga Tubes, the relevant portion is the relevant to this pinpoint. The oppressive acts must be continuous on the part of majority shareholders, and those acts should continue up to the date of petition, showing that the affairs of the company are being conducted in a manner oppressive to some part of its members. It has to be the continuous act. And again, the relevant portion of that English court judgment in Beldor Silks, this English precedent shed light on what the court should do in the case the petition is filed for the purpose of obtaining the money from the company. The court said the ulterior purpose of the petitioner makes the petition not bona fide. If the petition is not bona fide, the court is bound to reject it if the object of petition is to recover money from the controlling shareholder. It is an abuse of process of the court, and on that ground, the petition should be dismissed. Basically, to recover the money from the majority of the company, this provision cannot be used. The old judgment is still very relevant and being dealt by the judiciary. Yes, next. Again, in the matter of Suren Singh Vindra versus Hindustan Fasteners in 1990, the Delhi High Court made the observation there have to be the continuous acts, the complaint of the continuing up to the date of the petition, showing that the affairs of the company are being conducted in a manner oppressive to some part of the members, or a manner prejudicial to public interest, or in a manner prejudicial to the interest of the company. It therefore cannot be said that the events which occurred 3 years prior to date of filing of petition cannot be looked into if these events forms continuous act complaint of continuing up to date of petition. even the past act, which is having some continuing nature of occurrences, that can be taken into the record by the court. And this can be looked into if the far part of the continuous process continuing up to the date of petition, showing that the affairs of company are being conducted in the manner stipulated, so and so. Yes. Next. Again, in the era of post NCLT era, basically we have not come across with the number of judgments where whether the landmark judgment of the Supreme Court and the Mistri or all these, they have thought in the different grounds. We are here discussing with the conceptual understanding of operation and mismanagement, and still the old jurisprudences are relevant. However, I come across with some of the judgments in which the concepts were recognized and taken into the consideration. In the Honorable NCLT Chandigarh, in the matter of Sudevi Beriwal, relying upon the finding in the Palghat export, dismissed the application by holding that isolated act of operation or stray acts would not amount to operation and mismanagement unless the stray illegal acts may have continuing or lasting consequences. In such case, the powers may be invoked. Again, this petition was dismissed by the Chandigarh bench on the basis of that has to be continuous one and isolated act cannot be. Next. Now, basically, after this discussion, now we have reached both the number of judgments from one side to other side, and depending upon the law is already settled. We are having a number of jurisprudences, and old jurisprudences are still being considered and followed by the judiciary today, and it is upheld by the apex court in the number of cases. So with this, and since the law is almost identical from English to our 56 Act to 2013 Act, so just I'm having this conclusion, being the law is based on the facts in each cases. So just we are having 3-4 bulleted points before I conclude. Post 2013 Act, with the increased cluster of rules and regulations, the ambit and scope of categorizing as an act of operation and management has been widened up. There has to be, in the earlier era, the complete codified 56 Act. Now we are having that wide, most dynamic 2013 Act. And in this era, we are having the corporate governance, we are having secretarial standard and all these, and they are part and parcel of the statute. And they having this continuous violations of non-compliance of those, whether cannot be taken as appraisal and not. This is a very, or cannot be taken as the mismanagement also. That's can be the questions in comparison to when we are, and how much the reliance and reliability can be placed in the past era of judgment, and how they can be, to what extent they can be taken as the appropriate. Next, again, the general view as to categorization is that the conduct must be the burdensome, harsh, and wrongful, in which all the judicial pronouncements they have dealt at the lowest involvement of visible departure from standard of fair dealing and a violation of conditions of fair play on which every shareholder who entrusts his money to a company is entitled to. This particular terminology is already upheld and dealt by the various judgments time and again. Again, the 2013 jurisprudence and English course cannot be ignored and are sufficiently reliable. Even in this era of NCLT or 2013 Act, it cannot be ignored, and it was, according to me, are sufficiently reliable even today, subject to the dynamics of the changes. And determining or giving a view as to what constitute operation and mismanagement has to be the case-to-case basis, as the Supreme Court is already held. It is the matter of more of the facts, not the, and no instance an act and conduct can be generally classified as such as operation, oppressive, and all this. This is the basically I try to deal with the subject where here we are, since the mainly concentrating with this terminology, how much it is relevant, and we try to cover up the jurisprudence and position in that. As far the general litigation is going on, that there is again a very big subject on that, operation and mismanagement, and the number of cases may be that, but we purposely avoided and try to restrict ourselves with the true sense of these two terminologies which are relevant to deal